decided cases. Cardoso explored 4 methods of deciding cases when existing precedents did not determine the controversy at hand. First, the method of philosophy, logical experience progression or analogy of established principles, presumption that like cases should be treated alike. Logic is the default method for decision making. Second, the method of historical development, evolution, changing times, knowledge of history to understand a legal principle. Third, a method of tradition, the customs of the community, tests and standards for established rules. And fourth, the method of sociology, social justice, social welfare, the moral blinding traditional customs, and the prevailing standards of right conduct to include religion, ethics, justice, and constitutional law. Our group consists of Kim, Alexis, Alessa, Nate, and myself. And for discussion on Bowers versus Hardwick, over to you, Nate.
Bowers versus Hardwick, court case 1986. United States Supreme Court decision overturned in 2003 that upheld in a 5-4 ruling the constitutionality of a Georgia sodomy law criminalizing oral and anal sex in private between consenting adults when applied to homosexuals. In August 1982, an Atlanta police officer issued Michael Hardwick a citation for public drinking after witnessing Hardwick throw a beer bottle into the brush along Monroe Avenue after observing him violate the city's ordinance that prohibits drinking in public. When Hardwick did not appear in court, the court issued an arrest warrant for Hardwick. A few days later, officers went to Hardwick's apartment to serve the warrant. Hardwick's roommate was sleeping on the couch in the living room. The roommate invited the officers in and directed them down the hall to Hardwick's room. The door was open, and the officers observed Hardwick and a companion were engaged in mutual consensual oral sex. Hardwick became hostile and threatened to have the officers fired for entering his home. Both men were placed under arrest for sodomy, which was defined in the Georgia law to include both oral sex and anal sex between members of the same or opposite sex. The local district attorney elected not to present the charges to the grand jury, which would have been prerequisite to any trial and punishment for the offense. Hardwick then sued Michael Bowers, the Attorney General of Georgia, in federal court for a declaration that the state sodomy law was invalid. He charged that as an active homosexual, he was liable to eventually be prosecuted for his activities. The decision, the issue in Bowers involved the right of privacy. Since 1965, Griswold versus Connecticut, the court had held that the right to privacy was implicit in the due process clause of the Fourth Amendment to the United States Constitution. In Bowers, the court held that this right did not extend to private consensual sexual conduct, at least insofar as it involved homosexual sex. The 5-4 majority opinion in Bowers, written by Justice Brian White, framed the legal question as whether the Constitution confers a fundamental right upon homosexuals to engage in sodomy. The opinion answered the question in the negative, stating that to claim that a right to engage in such conduct is deeply rooted in the nation's history and tradition, or implicit in the concept of ordered liberties, is at best fallacious. White was joined by Justice Williams Rehnquist, Sandra Day O'Connor, Warren E. Berger, and Lewis F. Powell in upholding the anti-sodomy law, while Justice Harry Blackmun, William J. Brennan Jr., Thurgood Marshall, and John P. Stevens dissented viewed the law as unconstitutional. Bowers versus Hardwick, a decision largely contemptuous of homosexual behavior, was a serious legal blow to the gay community. This legal setback, however, was not long-lived. In 2003 case Lawrence versus Texas, the court declared a Texas anti-sodomy statute unconstitutional, ruling that homosexual sodomy is part of the fundamental right of adults to engage in private sexual activity. So basically, society changes over time. You can see in 2003, in the Lawrence versus Texas court case, that the Texas anti-sodomy statute unconstitutional, ruling
1972, the courts argued over the constitutionality of abortion laws in the U.S. After over a year in the court, Blackmun delivered his opinion. The court decided that although abortion was an emotional and controversial issue, to deny a woman the right to abortion is unconstitutional. Cardozo speaks of the impact of society on a judge's ruling. He says that over time, a judge must be willing to put his opinions aside, put his morality aside, and even put aside his own religious beliefs in order to adjust to the ever-changing society. If a society cannot change, then we are only holding ourselves back. Blackmun acknowledges this in his opinion by saying that although religion, morality, and even one's own personal beliefs of rights are argued in the abortion cases, it is not the court's opinion or ruling or decision as to whether or not a woman should be denied an abortion. A woman has a right to her own body.
The Espionage Act of 1917 made it a crime for any person to convey information intended to interfere with the U.S. Armed Forces, prosecution of the war effort, or to promote the success of the country's enemies. In Debs versus U.S., the defendant, Eugene Debs, caused and incited and attempted to cause and incite insubordination and mutiny among the U.S. military and naval forces. Debs was sentenced to 10 years in prison for violating the Espionage Act. The question in this case was, did Debs' conviction under the Espionage Act violate his First Amendment right to free speech? The court found that Debs' support of those convicted of opposing the draft, similar in the situation in Shinnick, was upheld, so Debs' conviction was upheld. In Shinnick versus U.S., during World War I, Shinnick mailed circulars to draftees. These circulars suggested that the draft was an outrageous wrong. The circular said not to submit, but advised only peaceful action. Shinnick was charged with conspiracy to violate the Espionage Act. The question in this case was, are Shinnick's actions protected by the free speech clause of the First Amendment? The conclusion was that no, Shinnick is not protected in this situation. During wartime, utterances tolerable in peacetime can be punished.
In the case Gitlow versus New York, 1925, Benjamin Gitlow, as a member of the Socialist Party, he was convicted and charged with criminal anarchy according to New York laws. Gitlow originally published an article titled The Left-Wing Manifesto, which violated the Espionage Act. Gitlow stated that there was no violent action that had resulted from this publication. After losing the case, Gitlow was convicted and sentenced 5 to 10 years. After serving 3 years, he later appealed his case, which made it to the Supreme Court. Gitlow was arguing during the court that his First Amendment right of freedom of speech was violated, which was leading to his unconstitutional conviction. The issue that Gitlow had was that the Bill of Rights should have been applied not only to the federal level, but also at the state level. According to Justice William Howard Taft, Gitlow's rights were violated given that the 14th Amendment, the right to due process, is rescuing the First Amendment right of freedom of speech. Oliver Holmes' dissenting arguments clearly states that there was no intention to create an uproar against the U.S. government, not now, not for the future. Therefore, the Bill of Rights applied to individual states and federal level, that this case was overturned. It was basically saying that the 14th Amendment helps with the First Amendment, so we all have the right at the state and federal level.
In closing, there are times when the subject matter lends itself almost indifferently to the application of one method or another, and the predilection or training of the judge determines the choice to pass. The restriction or extension of existing rules must let the welfare of society fix the path. Disagreements are commonplace, like gaps in social welfare. Testing of the social value of a rule is becoming a growing power and importance with judges. Liberty is not defined, but must consider the framework of present-day conditions that vary from age to age. The meaning today is not always the meaning of tomorrow. To speak of an exclusive interpretation over time is altogether erroneous. We must evolve